actually, I guess, past the witching hour. Unfortunately, we're going to be short on participants for a while. My understanding is that, I guess, the turnpike somewhere west of here is closed down. And I guess Mr. Koulakis is apparently going to be maybe a half an hour late. Dr. Berger, I think, may be quite a while.
Is it like 2 hours?
And,
Detours goes to Maryland and back.
Well, I would have preferred to start, to leap right into some of the naughtiest of the definitions, but I think we'll do better to have as many people as possible available to participate. So let's sort of fill in a bit in the meantime, if we can. And I don't know, maybe scheduling is something we can talk about a little bit. I believe that we have some various issues yet which may require the taking of testimony, may require us to schedule one more hearing.
Sorry.
That's okay. Mary, do you know what we have in terms of, there are some things we need to set hearings for, right?
Oh, yes, I'm sorry.
That's okay. And I'm just trying to remember exactly what. And Heather, do you have the dates, or can you put?
I'm going to pull them up in a second.
Great.
How you doing? Oh, do we have to be here? Isn't it?
Want to try and figure out what we are. You folks will have to bear with me. I performed my one major function of the day, which is getting Dr. Christian here. Other than that, I may not.
You did a very good job.
I may just snooze off now that that task is completed. And as I say, let's see if we can do some of the housekeeping and some of the odds and ends until we get is Judge Grimm, are we expecting him?
No, he's in Montreal, so we don't have.
I see. Okay, in any way, shape, or form.
I don't
Well,
think so.
that's the complexity and difficulty of drafting is sort of underscored by the time it's taken to get what we've got, and we're going to grind ahead today. Obviously, we've got a November deadline, which we are going to meet if it takes all the blood in all of our bodies. And actually, I'm very optimistic with the work product we've got in our hands already. We're going to do great. Is there, well, Mary,
Okay.
where the 21st is
Yes,
the, okay.
September 21st is going to be a hearing in Harrisburg where we are going to have the Department of Public Welfare present to you with regard to the status, the existing status of the whole child line operation, as well as the background check operation, as well as what their IT upgrade plan is in terms of how it will improve, hopefully in a very short time frame, and improve some child line operations, as well as overall with regard to the whole flow of information from the counties up. So Kathy Utz and her team will be presenting that. Vicki and I had the opportunity to do a walkthrough of Childline and felt very strongly that all of you needed to understand how critical the situation is there and what steps the administration is going to be taking to hopefully pour some resources in up front.
Not only, I know that what I hear, Mary, was that there are some structural upgrades and things that need to be done, but my understanding in talking to
civil service needs that piece right now, but we're actually trying to work with civil service to change the requirements for caseworkers across the system,
No,
not just
not-
the child line, children and youth too.
But what are the civil service requirements for a child line, for entry, just to be sitting here taking phone calls? You don't need a bachelor's degree, correct?
Right, so it's, most do have a bachelor's degree, but there's an out that says 12 credit hours for in human services. That's the same as for county children and youth workers also. It's not specific to child line.
I was just saying, as you were walking in, that if we're really wanting to entrust them with being able to ensure that investigations get to the right places, if we want to have like a, everything just comes through, remember we thought about the 711 concept or some just you're worried about child abuse, dial this number, you get somebody centrally who knows how to get the information to the correct place. You have to make sure that the workforce is capable of getting that information to the correct place.
And so what we do now, because as a result of Act 179, there was the change that said those calls come to child line regardless of who the perpetrator is. So our folks have a kind of series of questions that they'll ask, and one of them is related to the perpetrator. So they try to ask the referral source, is it a parent, person responsible for the child's welfare, a household member, or a paramour of the child's parent? So they'll ask those questions. If the person is not one of those, that's what's the deciding factor on whether it goes to children and youth or law enforcement. So if it doesn't meet one of those 4 people, they are sending the information to the district attorney in the county where the abuse occurred. So we're doing that now, and I'm not sure, we would need to change civil service to make that distinction, because we do have a series of questions that are very targeted to identifying who actually is alleged to have committed that abuse. And then we would send that to either the county or the DA.
Let me throw out a concept that at least has been floating around in my mind, and I think with some other discussions, maybe something that your job line people could be thinking about in the meantime, and I throw it out for what it's worth to everybody here. It occurs to me, particularly with regard to physicians, but really maybe if there are phone delays, if there are difficulties on any kind of a regular basis, whether there would be some obstacle to allowing the reports to be made by email.
From the mandated reporter to us.
Yeah.
So, no, I wouldn't say that there's necessarily an obstacle to that. What would happen is we would need, so somebody could email something to us, but then we still have to have somebody who was going to pull that record from the email, read it, and they still have to, right now, enter that data into the system. And so I think that what we would end up doing is there's still going to have to be some sort of manual process on our part.
And I wouldn't doubt that even if you get, and again, what I know about computers is ludicrous, but I could believe that you couldn't queue up an email even if you had a format. Maybe you'd get to the point where with regular reporters, you'd have the equivalent of a paper form that somebody would fill in, and that you could input some of the data automatically. And that's sort of one of the broad concepts I've taken away from this, and I think Mary's already addressed it, is the idea that the administration take, whoever the technical gurus are in the administration, and actually focus, hey, let's look at this, and hey, we're going to spend
It
some
should be just
bucks.
a web-based,
Right.
like,
And
Perfect world, the whole thing's web-based.
Right,
Absolutely.
that's the long-term plan.
Yeah.
So that there would be the ability to have something web-based, mandated reporter, permissive
and
reporter.
we're basically filling out some
Goes
of the
in,
information for you.
Fills out the
Sure.
information, exactly, Cindy, and that's where we really want to get to, that information then comes. We get an alert that says, hey, here's this referral. We go through and look at it to make sure that we have the information that we identify, is there a perpetrator identified? Is there, who does it go to? And then we electronically submit that to the county. It goes into our system, it goes to the county.
And then you also
And
don't have
then
to have
what
us
would happen,
sending-
correct, and then what would happen is the county would get an alert on their end that says, you got this new report. They go in, they pull it from the system, they read it, and then click a couple buttons, and it's automatically in theirs too. So that's really our long-term plan, so that all of that is electronic, because the emailing piece just gets it there more quickly. It doesn't change the kind of manual processes that we currently have. And our long-term goal is to really streamline and make it more efficient.
Yeah, well, obviously, there are certain things we heard, for instance, from some of the doctors who testified about the dysfunctions, and maybe we can bypass, or, help those along. It's sounding to me like maybe the most useful thing, we'll make specific recommendations, but the most useful thing we can do, it's not like you guys haven't thought about this stuff, it's getting it prioritized up to the point where somebody's actually going to do it. So that's one of the subjects we're going to deal with on the 21st. Yes, ma'am.
But one of the things that you do have to make a policy decision on is right now, the act says that children and youth has to orally or in writing transmit that information to the district attorney. So policy question is, the call comes into Childline. It's a non-caretaker offender. Should that communication, obviously we will amend it to say it can be electronically transmitted. Should that communication go to the police department with primary jurisdiction, or should it go to the district attorney who then determines that? Kathy and I were talking about this. Kathy said the reason the DA was put in there is because you get the call about the abuse. If it's a non-caretaker situation, the abuse may not have occurred in the home. It could be information coming in so that their office, Childline's not clear about the jurisdiction issue in terms of who should be called. That's why they recommended that the DA be involved. And that's why I thought, can we have
Actually,
Lieutenant
you
Rocco
anticipated,
introduce
yes.
our new member?
Yeah, how you doing?
And then-
This is Trooper Pat Zerpoli. I'll let Pat introduce his background here a little bit, but right now, Pat is our unit supervisor for, we have a criminal investigation assessment unit within the state police. And they're kind of like specialized positions. There's one man per group that belongs, or per troop that belongs to this unit. And what they specialize in is major case teams, unsolved homicides. But part of their duties too is past duties is putting together our child abuse conferences. Pat's very familiar. He's been in the crime. I'll let him explain that, but he's really more of an expert in this field than say myself. So I brought him here today because I knew we'd be discussing a lot of this, and he probably has a lot of good ideas. But Pat, just tell me a little bit about yourself.
My name is Pat Zerpoli. I've been with the state police since 1992. I went to crime room in Swiftwater in '93, and basically centered my career around child abuse investigations. In 2001, I made 192 arrests in child abuse. So I put on the child abuse conference. I've taught for PCCD before in the 90s on child abuse investigation. And not that I find myself to be an expert in it, but I kind of focused my career on this. And listening to that with Childline, I just like to make this comment. There I think is a breakdown in the system. When Childline sends that to the district attorney's office. When we're talking about rural counties in Pennsylvania, which most of the state is, that piece of paper will go to the DA's office and just churn there. We, the state police, might not see it for 20, 30 days. I mean, I've seen them come out 3 weeks later to our department, okay? It should go to the law enforcement agency that is in that area or covers that area. Or if you can't decide on that, let it go to the state police who cover that county and let them make the decision if they're going to be able to do the case or it's a local department that does the case. So like I said before, I've seen that, and I've seen some very serious cases in my career that have sat at the DA's office for almost a month, where we have continuing abuse for 30 days, when we should have been on top of it day one.
Is there any reason to send that report to both, like the
facts, and one of the, just the
But-
basic facts about Pennsylvania is it's so incredibly diverse. You go all the way from Philadelphia to the suburban counties where I would like to have that information coming into my office. It goes immediately to a senior DA who's in charge of special victims, children's section. And so far as I know, it doesn't churn, but I can well picture the office I joined a bunch of years ago, that if that would happen.
Yeah.
But you also don't want to diffuse responsibility, like you don't want like the DA's office saying, oh, went to the police, we thought the police were doing something with it, or, as long as that's not gonna happen.
I mean, it gets sent to us anyway, so but maybe
Yeah.
an email to them so they can keep track of it, and whoever he puts, DA puts in charge saying, all right, what's the status on this one, where we at this investigation, somebody that can keep track on that, and I don't see that.
Exactly, and especially where one of the other models that I hope we're going to be trying to drive out here is the multidisciplinary, children and youth are frequently going to get word about this, and again, that, depending on your experience, may have absolutely no useful effect, or may be the source of the law enforcement referral to begin with, just depending. Yeah, I got no problem with it going to police if you can figure out what jurisdiction
And I
we're
think
talking
that's
about.
the trouble, and I think the solution that Troopers of Foley is recommending, if everybody, like if the law enforcement community is okay with, if we can't go to the municipality, because a lot of times we don't, we're asking the questions, the mandated reporter knows that the child has been abused, but may not be getting into those deep end questions to say, where actually did that happen? And so oftentimes, we've had cases where, in the rural communities, it happens out on a back road somewhere. And if they're not asking that level of detail, because the mandated reporter isn't doing the investigation, the child has disclosed, they're making the report for someone else to start it. So we try to, at Childline, get as much information as we can about, do you know where it actually happened, to be able to make that referral to the appropriate jurisdiction. But a lot of times you can't get that detail about who is going to be responsible for the investigation. So if folks are okay with it going to the state police in the county where we believe the abuse occurred, based on the information we know, that's a workable solution, I think, for us, to get it to law enforcement and the DA, or however folks decide. We just have really a lot of time, because we're not doing the investigation, pinpointing what municipality is going to have jurisdiction.
Well, what about the municipality where, if the information isn't gotten out, the municipality that the child lives in, isn't that a place to start then too?
Well, that was what we talked about too, is that, but we also know that many of those aren't happening in the municipality where the child lives. But if that's
But-
fine,
That department's off that.
Exactly.
But
I'm fine
again,
with that,
you're making an assumption that the child, which would be true most of the time, that the child lives somewhere in the county.
Is that,
So my thought would be, and again, just kicking this around, would be that the report go to the district attorney's office, go to whatever police department or state police is designated, or to another entity to be designated by either the DA, or if you don't want to trust the DA solely, to the, what is the thing PCCD created?
CJAP?
CJAP, yeah, somebody has to designate, not to the CJAP.
But how about this? How about if we say, if the childline worker knows the municipality where the abuse occurred based upon the report, it's a report to that municipal police department. If the childline worker cannot obtain the information, it goes to the municipal police department of the residence of the child. And
If
then
that's
that,
known.
Yeah,
and then that
yeah.
PD works with wherever.
Yeah, because in the course of the investigation, if they find out this happened in the state police's area, whatever the case may be,
Yeah.
it's going to be
Right.
referred to anyway.
Right,
Sure.
then we get it into the hands of the police agency immediately,
Right.
with a simultaneous
Notification of the
notification
liaison.
to the DA.
Yeah.
question and a comment, I'll start with a comment. Kathy, on the CY 47, as they're now written, I don't think there's a place that asks where, like, do you know where the abuse occurred?
absolutely.
to the CY
I think
47.
once we, yeah, and once we begin that electronic process,
Right.
absolutely, it would be where did the abuse occur?
That's
So
right,
that somebody
because-
can plug in an address, if they don't have a specific
They can at
address,
least
at
say
least
what
the county,
township or- right.
exactly.
And then, that was my comment. And then my question is, so I honestly don't know what happens, like if the kid lives in Philadelphia but was abused in
Okay.
Lehigh County, like, then.
Lehigh
then-
County
Okay, yeah, then,
is where the abuse occurred.
okay, but like, does children and youth in Lehigh County investigate it, or children and youth in Philadelphia
It-
County? Where the
It's
kids
assigned to the county where the abuse occurred.
Okay,
So Lehigh County in that scenario would do the investigation, but would be connecting with Philadelphia County because that child's a resident. There may be courtesy interviews that are occurring back and forth,
okay,
but when you're talking about then at the end for the provision of any services that might be necessary, those would be happening in Philadelphia rather than in Lehigh County. So we encourage counties to work together.
right.
Sometimes it
Okay,
works
so
better
we
than
want to
others.
investigate in the county where it occurred,
Right.
so that you can have the police and children and youth both investigating together.
Yes.
Got it, okay.
And then, but we will also make this communication be immediate,
Yeah.
Yeah.
right? Because the other issue in terms of how this extremely awkward provision with regard to what children and youth must provide law enforcement in 634010 sets forth what the department has to give law enforcement. But in the opening paragraph, it says law enforcement shall receive immediately after the county agency has ensured the safety of the child reports of abuse orally or in writing. And from a practical perspective, that's not what you're doing. It comes into child line.
It is what's happening for the ones that are investigated by the county. So 6340, A10 applies to when the perpetrator is a caretaker. So
Oh, I'm sorry.
those are the ones that the county's going out, they're doing the investigation, they assure safety, and they're doing that immediate referral to the local jurisdiction and the DA at the same time. So that's the CY 104 form that goes back and forth. 6368 is the section that says if it's something that can't be investigated by us because it's not a caretaker, that we refer it to the district attorney.
Okay.
And now we're going to add the appropriate police department.
And immediate, rather than snail mail. But getting back to what you just said with regard to if it's a caretaker who's perpetrating the abuse, how do we reconcile that with the multidisciplinary response? And Trooper, it might be helpful there in terms of who do you want on the scene immediately in terms of evidence, gathering of evidence and making it, a response.
I think, again, in that situation, it should be law enforcement added to children and youth. Children and youth is notified immediately if there's a caretaker involved,
Right.
under that definition. Children and youth then notifies us.
Once they see to the safety.
Once
of the
they,
child.
yeah, once they figure out what's going on there, but it's a lot easier if everybody gets notified at the same time. You know, we're trying to go with, and we have been for years, with that multidisciplinary response to everything. You know, and sometimes, we're delayed sometimes with the notification of children and youth again, for many different reasons. And in this day and age, and with everybody looking at law enforcement in cases like this as being so evidence-driven, like everybody's saying, you know, there's got to be physical evidence, there's got to be physical evidence here, we're living in the CSI world. We like to do that. You know, when we go to scenes, and I've done it before, if I have a perpetrator who's allegedly masturbating in the house or the child's room, I want my FSU guys there. I want them looking for evidence, I want them being the black light, you know, looking for something there. You know, and that gets us in right off the bat. You know, because sometimes children youth inadvertently makes notifications to people before we're notified, and then then our perpetrator is also then notified.
Yep.
So, yeah, I think, you know, I just think adding that, attaching it to whatever notification you do, the police get notified independently and at the same time, kind of, I think pushes it to the forefront where it should be.
And the other part of that, and I'm, frankly, I keep asking people in my shop to make sure it works. I'm just relatively recently the DA. There's that section that says that the DA does something about the response and multidisciplinary. I mean, my understanding is that my children and youth people in Bucks County understand just exactly what the trooper was just saying, that you don't notify, if these people aren't already on notice by the circumstances, you get law enforcement first, before you go walking into the home and alerting everybody, so that you can have that kind of, absolutely, the physical evidence gathering is critical.
And I think,
And I'm maybe naively assuming that happens, if
Well-
but if it doesn't, man, you're absolutely right, we're just turning people loose.
And I think we go back to the issue where it's so diverse with the state we live in. I think that's the problem. You know, like Lancaster County, I don't know if anybody hears from Lancaster County, has the best MDT response in the state of Pennsylvania, probably hands down. You know what I mean? They work together all the time, it's immediate. When they're notified, they're there on scene, and it's everybody. District Attorney's Office, Children and Youth Organization, law enforcement is together at the same time. You get to some of the other counties, they don't even have written protocol on MDTs. Bottom line, and I know that because I did Troop R's area a couple months ago, who has written protocol for response to issues like this. Some of them don't have anything in writing. I wrote Wayne counties. Well, actually, I wrote Monroe County years ago, then I wrote Wayne counties, and I wrote Susquehanna counties for them. You know, and everyone, and I'll tell you right now, I believe that, since we're talking about MDTs, the state should have a state plan. I mean, this is the state plan that everyone follows. This will now be adopted by
You
every
wrote it, is
county.
that it, right there?
What?
You wrote it, it's right there?
No, this is what I brought for today.
From a couple hours overtime, no, right?
Yeah, I'll write it for you. But you know what I'm saying, you should have a state plan that says, look, by law, this is what every county should do, and this is the county's response to these incidents. Because I'll tell you right now, and anybody who wants to jump up and down and bitch about it, this is about the kids. It's bottom line, it's about saving kids and helping kids, and if they're not on board, you know, get out, you know, and bring someone else in. But you know, that's the issues that we have in the state. I mean, you don't see them in the bigger cities, Dauphin County, Philadelphia, Pittsburgh, but you see them in these outlying areas.
Yeah, yeah.
So can I ask a question just in terms of drafting? So were you saying, for example, in Lancaster County, not Lancaster?
Lancaster.
Say it the best.
I know, that's why I've never been there. Yeah, I'm actually from New Jersey originally.
I lived there as a
Oh, that's
child.
Yeah, that's the problem right there. That's why I'm so outspoken.
So from a practical perspective in Lancaster,
Yes.
when, let's follow Ted. So when they've got evidence by a caretaker of any of the crimes enumerated,
Mhm.
Lancaster County's response is to respond to a home, or do they talk about it and then decide who's going?
From what I gather in talking with Kerry Stanley in Lancaster County, they talk, Lancaster?
Lancaster.
They talk about it together, then they respond as a team. You know what I mean? And that's what it should be. It should be, this is a team response. I've been jumping up and down this for 20 years, that we have to respond as a team, we have to respond, you know, collectively to something like this. Because, you know, one of us is not as smart as all of us put together, and that's the bottom line, and that's why I say that.
Okay, let me take it one step further. One of the recommendations we received in testimony, particularly from district attorneys, is to remove the exception, because right now you do not get reports of endangering the welfare of children, 4304. So one of the concerns is if we now require DPW to add child endangerment to this list, we're going to have an overwhelming burden
On what, police?
on, on police in
I
terms
mean,
of,
I'm just thinking about the number of calls that
That
come
you
into
see.
Philadelphia
Correct.
a day
On
to
child endangerment.
DHS.
For an endangering, well, I mean,
Neglect for, like, for all, right, for
that could
all
fall
these-
under in child endangerment.
Yeah. I don't know if you have enough special victims unit police officers, or even 911 cops.
Well, that's why I asked the question in terms of first there's a consultation before you're sent out. So if there's a consultation and it's that we're going to send out CYS,
CYS, yeah, because,
we will not have a
Right.
police report, but there's first an initial consultation.
no.
Well, but that can be as simple as a phone call.
Right. That's what I mean.
I
That's
mean,
what I mean.
if what's being reported is that mom was driving drunk and had the kids in the car, you know, number one, that's likely, unless it's unsubstantiated in the sense that a police officer didn't stop a person while they were driving, you got, grandma calling in and telling on her stepdaughter or something. There's not, I think the people with a phone call are gonna be able to resolve that. I would err on the side of loading it up. And
I
I
just-
agree, having at least a model, you gotta be so careful. I mean, you've outlined a number of counties, they're all tiny compared to.
No, I understand it, no.
Even how you say Lancaster.
Yeah, I understand, but I think the problem is here, the definition of neglect and abuse are two different things.
Right.
You know what I'm saying, and that's the problem, and when we see things come into children and youth, you'll get neglect reports coming in that we're never involved in,
Yeah.
that are not reported to us because they're not reporting abuse, they're not reporting sexual and/or physical abuse. From children and youth's investigation with that neglect, if they come to something that says we have physical or sexual abuse here, then they will then call us in. And I think it changes what I think then you have to call back the child line, you know what I mean, and report
Why would
something
it be
new.
like that there needs to be kind of a police child welfare response for every CY 47 getting, like, that falls into the CPS? You know what I mean? Because most of that neglect comes in under GPS, and we haven't decided we're getting rid of GPS, so.
No, but if we pull in endangering the welfare within the definition of abuse, you're going to get some overlap potentially, but
But so-
again, that's all, people sort out, human behavior is infinitely variable, and that's what police officers and children and youth workers deal with.
Yeah, that's why I asked in terms of just drafting this, if we require multidisciplinary response, our talking points are, that doesn't mean a police officer responds to every case. That means there's collaboration and consultation, and then there's an agreement, or maybe a disagreement,
Well-
with regard to response.
I'll tell you what happened in Wayne County when I was there. They would call me on almost all the ones that they got. Like, they would get one and they'd say, hey, this is what we have. What do you think? Well, you know what? Go out, and if there's something there, give me a call and I'll come out. Just let me know. And a lot of times we never got that follow-up call from them, from children and youth. I mean, but then also they would call and say, hey, we have to go to the kid because he's going to report sexual abuse. But they would just give us that courtesy call, and just that 2-minute conversation out of my day, we kind of resolved that issue and off they would go, and it's nothing that we responded to, and a lot of times we didn't respond to things like that.
That's it. The key is establishing the relationships, and if the people are halfway decent, they'll work out the
The nuances of everything that's going to go on.
So I guess then, Troopers, one of the things you said is there should be a statewide plan protocol. So under current law at 6365C, it says that the DA develops the protocol for the local county. So I guess then the question is, are folks recommending that there be one kind of statewide protocol, or should it be left to the discretion for the DA to determine how that works in their individual county?
And what I'd like to do is, let's see if we can get somebody from the DA's Association by the 21st who wants to opine on that. And actually, I just talked to the DA of Lancaster not too long ago because their school people weren't being as forthcoming. Imagine that as like a desire. So, he might be interested since his county's just gotten the seal of approval. But let me see if I can come up with somebody, and Trooper, if you'll be
Philly
available.
also just like has a fairly new protocol that's, I think, working well, so you may want to, I don't know, I know it's
Yeah.
like Goliath, but or you may ask someone to actually collate what's known around the state, what protocols exist.
Well, why don't we see if we can get Lancaster County to testify?
Yeah.
Why don't we do a best practice? Why don't we have Lancaster County testify, and that might build the foundation for the recommendation statewide protocol. One statutory precedent for the statewide protocol is the Safe Schools Act requires, we have a model MOU, a model statewide MOU. The legislature created a task force that's in statute, the PSP staff, Department of Education staffs, and PSP actually, I think, was the driver in terms of a model MOU every school district in Pennsylvania has to have an MOU with regard to law enforcement response to incidents of violence in schools. So that could be a model for us in terms of, we want to model MDT. We can have experts at the state level put the model together, have it adopted, so to speak, and then
Another thing that we've seen done more with protocols like that is for the state to establish minimum standards that they want the protocol to have, and then leave it to the discretion of each county or each DTA to tailor that
Right.
to fit their
And that's
circumstances.
what the
like
MOU
we
is
have.
as well, like Philly's gone a lot further in their MOU.
But if you have that model policy out that people can look at and say, okay, these are, like I said, the
Four
minimum.
elements.
And then a local, then a smaller DA's office can tweak it, and a bigger one can.
Now, in Maryland, with their, I think it was eyewitness identification, they actually had each department coming up with their own, but then they had to file that with the department so that the access is accessible to the department and to the other police departments on their website if there were conflicts or they needed to look at anything, so that there was a central repository for each jurisdiction's protocols then.
Kind of an interesting approach, but,
Do we have someone who actually could ask different counties who has like a protocol or can you do that?
What we actually did,
Okay. Did you do that?
we did, it was probably about 2 to 3 years ago, the Children's Justice Act Task Force, and Sean McCormick is actually the co-chair of that group. We surveyed and got copies of all of the county protocols that were in place, and there was a group, a small group of folks, children and youth, a couple law enforcement folks at the time, and then some of our staff who went through those and looked at them. And so one of the things that happened next was there was a survey of questions that were developed. And there were phone calls made, and I can't remember if it was all 67 counties or some counties, to identify what was happening. So was it working? Because one of the things that the group identified was you could have a really beautifully written protocol in place, but if you weren't executing it, it was only as good as the paper that it was on. And so their phone calls were made back to see if they had a really nice protocol, were they actually operating it? And some yes, some no. And then some of them we actually called where the protocols might not have been the prettiest on a piece of paper, but we had heard that they were doing good things. And so while the protocol on the paper didn't look good, their practice was pretty good. So Sean could probably, help us in that regard because we did do that already. And that group is kind of moving, and their next steps were to do exactly what Yvonne was saying. What are some common standards? What should be a set of standards for multidisciplinary teams, just as a guide that then could be put out? So we have some work, and then through one of the Children's Justice Act grantees, they're actually doing some additional work in that as well.
and what, this is an already existing entity created by some legislative enactment.
So what the Federal Child Abuse Prevention and Treatment Act has a couple different portions of it, and one of it is related to Children's Justice Act grant funds. So the state gets about, I think it's about $700,000 a year. And what we did is, in order to get those federal funds, we had to do a review of what our protocols look like currently. So that's what really led to that and us being able to get that grant.
Well, let's, in the interest of moving on today, I'll reach out to Sean, to Lancaster, and to Greg Rowe with Philly, and, we will get some kind of presentation for prosecutors, and we'll have representatives from the state police here to just, we can almost have a panel discussion, doesn't have to be formal testimony so much, to emerge with some kind of specific recommendations as to what happens there. And it sounds like really that stuff is being put together in a lot of respects.
But we can, in our new law that we're, or in our recommendations, just have some language kind of mandating certain
Right.
standards.
Or that something get created.
That's right.
Yeah, I don't know whether we want to micromanage, because state-of-the-art communications may change over time, and you don't want to have to be
No,
going
well,
back to that's the,
Notifications, who's involved, just basic, broad.
Like she said.
I mean, that's the other hurdle that I think we're all of a mind, but I don't know that we've actually got to the drafting of that, is this whole issue of, are we going to mandate that every county have a multidisciplinary team? I don't know that we had gotten so many of the smaller counties. I think our hope was that at least, and they're not exactly the same thing as a CAC,
Right.
but our objective would be that there be a CAC within some geographic accessibility. That's not necessarily going to relate to the county, and you could still have a multidisciplinary team within the county, but I suspect that, we have to be a little bit careful about a template in such a diverse state. Jason?
Mr. Chair, I need to formally apologize to you, the task force, and our esteemed state police guests. But on that note, I think we need, I think we should suggest and recommend that every county does in fact have a multidisciplinary investigative team, not necessarily require a CAC in every county. The MDTs can travel, and that's why we talked about having them within an hour's travel or something like that. But I think it's important that we should suggest that each county develop an MDT relationship to help the collaboration between those professionals. Some counties do it very well, some counties don't do it at all right now.
Yeah,
Um,
I agree with Jason. I mean, I think as opposed to like having a whole CAC, you have to have, it's an approach to the job, an approach to the investigation.
And the only, again, I agree with you, except that Jason used the word suggest, which we can't do in legislation. We can, I mean, either we're going to mandate it, or it is just a suggestion as sort of a best practice kind of thing. And I'm not sure whether we can mandate it,
Okay.
just realistically.
Don't you have like a police
Frank-
officer and a children's youth worker in every single county?
Well, if it's just a police officer and a children and youth worker, I'm really hoping to have medical involvement, and that may be the thing that is not.
And I think there's a way to do this, and we can talk about this without taking the time here. I have some ideas of how we can do that with some minimums and in some consultation where required for the medical team with the prosecutor where required, that kind of thing. So you can still have the minimum requirements of the MDT in each county.
And that's the thing, I think the idea of a sort of a basic standard, that a minimum standard that the state sets, the ability of the DA or whoever to expand on that so long as you meet the minimums, is probably the model to go after. But that's an issue for the 21st, and now you just noted the 20th?
I thought the first availability was 21. It's 20 and 21.
Oh.
In terms of everybody's availability. And Vicki is saying that's the last Friday before session. So the 20th would probably be better.
Let me just ask you guys in general, and again, it was the summer. I had envisioned when we were last together here that we'd have every, conceivable piece of paper. And one of the problems is Yvonne is too good and is too focused on, this is ready for legislative reference, when, at least the way I envision things, is let's just get it down on paper so we can kick it around. So we haven't gotten everything we wanted, or at least everything we've talked about. Is it realistic to say by the 20th that, not in good form in every intricacy of
Every bracket and underlining.
yeah, but just sort of something that we can all look at? I hate this business of one day, and I don't know how many days there are in October that we've got identified.
We have 3 dates in October, October 3rd, 19th, and 24th.
If we've got 2 days together, and we're still down some members, so that this isn't universal, but anybody have a problem with the idea that we schedule the 20th and the 21st? If it makes more sense to have the hearing on the 20th, fine. But, and I know it costs the taxpayers some money to have people stay overnight.
Yeah, we need to check the finance department with regard to the ability to pay for people to stay overnight.
Where is it going to be? Would it be here?
Yeah,
We
we're not
take,
gonna
we're
travel.
sleeping
I have 2 guest rooms.
I have a guest room.
Yeah, I do
I
too.
sleep for sofa.
Let's at least And then, well, first of all, is that gonna discommode anybody you've kept the dates open? I just have the sense that by then, let's see if we can, the more stuff we can identify that we're all on common ground, if the language needs some fine tuning before it's, hell, this stuff isn't gonna get drafted until next year anyway, in terms of bills going into the legislature. I'd love to get as many issues checked off as we can, so that we, because I've got at least one idea I'd like to throw out that might require hearings, that might be a whole different thing. Maybe, actually, you had somebody ask you a rumor about, was something going to get dragged into next year? And in fact, just let me take a minute and throw that out. The more, and this, Jason, you probably know more about this than anybody else, the more we think about, on the one hand, you were swallowing your tongue, whatever hearing we had, where people were talking, I guess it was in Philadelphia, about how unfair some of these categorizations of people that don't keep their house neat, you know, compared to somebody else's standards, so they get labeled a child abuser and can't work in these fields. On the other hand, you've never lost one, you know, everybody who got designated, whatever your county was, they, you know, they were absolutely scoundrels. There's something I don't like about this process. The idea that you got unevenly trained children and youth workers dealing with people who, for the most part, are going to be the least sophisticated responders to government. And it sort of mirrors, and I don't want to throw out for public, you know, for discussion, a politically sensitive topic, but, you know, all this hoo-ha we're going through about voter identification is at least in part premised on the idea that some people have a lot more trouble dealing with government than others, you know, whether it's to get driver's license or hunting license or whatever. And we're taking a lot of people who may have the toughest time dealing with government, slapping this, okay, you're now an abuser, not because you did some terrible grievous damage, but something. And then if you don't respond within so many days, you're labeled, you've got this crazy appeals process. Whether it's appropriate, and I'm not trying to get the discussion going now, but I'd like you to mull, is it worth our having the discussion that we change that model, that we say, okay, the children and youth worker is the person who makes this determination, but there is a process controlled by the Court of Common Pleas, you know, so here we go with resources at the county level, where within a reasonable period of time, you get to appeal that. Maybe it has to be founded in any case, even if it's not challenged. And it's going to be a master in all likelihood, rather than the children, you know, the judge who hears juvenile or dependency cases. But it has to, that determination is not just going to be a social worker's determination if, or somebody who was trained in something else. The art history major or professor, it has to flow through some lawyer who is trained in this area, who has to, in a sense, bless it right then and there. And then if it's contested, obviously, there's the whole appellate process that takes place right then. It's an expenditure of resources up front. I don't know what the numbers are about the whole appellate process separately, but I felt uncomfortable about this. The more I learn about this process, the more uncomfortable I feel about it. The potential for doing injustice to some people who get labeled child abusers, and just the potential for unevenness. That some places may be people who would be in one county called a child abuser, and in another county it's like, oh, well, what the hell?
And
Is
the
it-
large counties in one unit and not another.
Isn't we a dialogue on this right now, or?
Well, I'll throw it out, and you mull it for a bit. That's a subject that we haven't gotten into. I don't want to bog down. We got too much other important stuff to do, that maybe that's just an idea I keep in the back of my head.
No, I have to say that I think that it's an important issue. And I think it deserves some thoughtfulness. I don't think now is the time. I think we have like some very basic things we have to work on. Like what's our definition of child abuse in the state, like all of these other issues for today. But I don't see why we can't take a day in
upset the apple cart completely, that is, remove it from the DPW appellate process versus working within those confines to require certain procedures, put procedural rules in there to fix the system so that there are, just like you would in court of common pleas, if you're gonna take it and move it to the court of common pleas, you need to have a procedural rules created to make it navigate the system and do it appropriately. We could do that here and fix the system so there's a prompt hearing, so there's immediate relief available or prompt relief available versus 9 months till you get an outcome.
Why don't you, like, I mean, I'm just thinking, like, why can't you have a system where in order to go on your registry, you have to have a hearing, as opposed to everyone where there's a, like, I mean, again, if you just step back and you rethink how, like, how do you put this together, like, that,
That's, actually, the Commonwealth Court opinions that came out this summer on the expungement cases, that's basically what they're calling for us to do, is establish a hearing procedure on the indicated case before it goes anywhere else, because they're setting a standard of substantial evidence, and that
Clear and convincing.
clear and convincing, I'm sorry, yeah, that the substantial standard isn't enough, that it has to be clear and convincing. And so that in order to go, you can indicate the report, but if you want to release it to an employer or to the child registry or anything else, that indicated report has to be backed up by clear and convincing evidence. And their recommendation in one of the cases was, you don't have it now, but the legislature should consider establishing a hearing process, it's in the footnotes, a hearing process where you verify that there's substantial evidence before that report moves any further in the process.
Well, I'll tell you what, it's at least a subject about which there may be some interest in order to, and that's, you know, we have some expertise around this table, but if we were gonna do anything about this, and I'm thinking maybe this is enough that, and of course, unfortunately, Judge Grimm can't be here today, that JCJC and the juvenile court judges at least be aware this is something that could go their way. I don't honestly understand much about I want to hear about the appellate process with Department of Welfare, but my first bias as an almost New Jersey and living right across from Trenton is I want Harrisburg as little in Bucks County as possible. And so my bias is for that, but I like it, you know. So it's a subject we can talk about. Getting back to now tentatively the 20th, are there other subjects Greg, a while ago, and actually I think, and I guess, Jackie Bernard's also delayed thanks to the Turnpike Commission's. We know it's an accident.
Tractor trailer accident.
Okay.
They hope to be here by 10:30.
It's, anybody going that on the turnpike, it's gonna be shut down until at least 4 o'clock.
Yeah, I thought
Oh,
it was
geez.
4 o'clock.
At any rate, the subject had come up, and I think it may have had to do with the internet and child pornography, that, which is certainly, if there are laws that need enacting, it's a proper subject for this.
Well, and let me introduce, this is Corporal John O'Neill. He's actually our unit supervisor. Asked him today about unit supervisor computer crime across the state.
Okay.
And I kind of brought him here in case the task force had any questions on it, or, on what we do relative to child porn investigations, or how we assist, whether it's travelers or whatever. So, he's here and available. I don't know if there's any particular areas you would like to see addressed as far as, I mean, you can bring up the administrative subpoena powers and different things like that, but why don't you introduce yourself?
Good morning. As far as law at the moment, I can't think of any adjustments. Administrative subpoena powers are something that we're very hopeful, just as far as IP addresses, just the initial identification. It would limit jurisdiction, or help us identify jurisdiction. It would cut a huge amount of time to get these investigations started.
And where, so that, where is that, when you say hopeful, is there legislation pending? Is that getting whacked around already?
It is, and we're hoping it's going to be introduced and as good possibility of going through.
He's actually testifying to that, when is that hearing? The 15th? The 18th of September, he went out to Allegheny County out there to, and I can't, you know who the senator is? Or who he- But anyway, our legislative liaison had prompted us to develop some testimony, which we're going to be doing here, and he's going to be going out testifying to why we were looking for administrative subpoena powers, how it would cut off time on our investigations. And John, if you want to give just a brief, I mean, does everybody know what we're talking about here on this end, or no?
Well, but let me make a suggestion. I do.
Okay.
And what occurs to me is, if you say it's the 18th, you're going to be testifying out there.
Correct.
So you're going to be preparing canned testimony. If you could submit that, make sure staff, or just get to my office if nothing else, we get that testimony. I think we can distribute that to the committee members. Hopefully that will be sufficient. Because that's exactly what we're good for in some cases is digging down in this stuff and creating things, but also as sort of a bully pulpit or a way, hopefully this report is going to be paid attention to by people. So even if you're pursuing it separately, it's a proper subject for the Judiciary Committee, there may be, the issues of due process and
Well,
civil
I
rights.
was actually going to suggest that, is that, we're going to be providing testimony, so even some written testimony by us relative to that would save time anyway, because, instead of having to present it, on our end.
Right.
Is the task force going to be addressing any, I know there was testimony on different funding for all kinds, are they going to be addressing any type of funding issues in the report, or are you guys kind of staying clear of that?
Broadly,
Okay. Because
certainly.
one of the main problems we have, at least, and the way our department works is, John's in charge of our computer crime unit, but with that, we have 5 computer crime task force that are set up across the state that have local police department, local members that are also on our task force, and obviously, training and equipment. I mean, ever-changing technology and everything like that, so unless we receive like a huge COPS grant, which just ran out, the funding on training, equipment, and stuff to keep, of all this stuff, too. That's what, am I right, John? I mean,
In addition to that, our task force members, we have task force members, but often they have to reach out and piecemeal it for equipment or some training we may be able to help them with. But that additional training would be able to help us. It's also help task force members to increase our presence across the state. So
Crickets are good luck, Jason.
and, just a different software.
Don't kill the cricket.
Just a different software when you have it like that. I mean, just the upkeep of renewing licenses for the software is incredible. The amount of money, and that is ever changing. I mean, there's equipment that we have now that 3 years ago was state of the art. Well, now we're not picking up anything on cell phones. You know what I mean? So then we had it. So I mean, that's kind of the main issue I have with our computer crime unit is that it's great, we can do a lot of things. I think we can do a lot better, but the problem is funding directly related to computer crime investigation, because they not only assist with child pornography investigations, travel investigations, but they're breaking. Tell me who doesn't have a cell phone, smartphone, or something like that we're constantly digging into these days. So that was another area that I wanted to see if we're addressing with that at all, because I don't know how many investigations we have, but anytime there's a child pornography investigation or abuse, these guys are getting contacted. And it's whether to go through a computer or whatnot, or even doing proactive investigations.
I just have a question generally, just to help us, and for the record, to understand how pervasive the child pornography industry is in the Commonwealth. Can you give us an idea what kind of volumes you're talking about, the extent of the scope of what you do, so we understand it?
there are more cases than we can work. To give you a number or statistic would be difficult, but there are always more that we can proactively search for and find.
And are you talking about the sharing of images or the production of stuff?
Well, the sharing aspect is largely what we do with, with proactive investigations. Intermingled with that, I think, around too, is the production and distribution of it, but it's the sharing of it on the internet and stuff that we get heavily involved in on proactive investigation. Am I right?
That generally leads us to people that are producing. They may
Hopefully.
produce a small amount and share a large amount, but that's usually our way into those type of
And
information.
investigations generally go from picking up somebody on the web who is, you find them in a chat room or something, and they're you start communicating with them, which leads you to the individual.
Correct, it could be that way, or just, they're called peer-to-peer programs where they are actually sharing, they open their computer up, a section of their computer to another individual, and they share through those folders that they make accessible, and that's how they distribute large amounts.
And how do you get onto them, if you will, or you just have the same programs?
We actually have an
Phishing
expert that can testify on that. We have a program that we use.
All right. Together.
Should we add another table down there?
There's one over here.
Yeah.
Let's do another table.
How are you?
But-
I know. Certainly made enough phone calls though.
Well, either do one here, Rachel, go here, are you okay here? Yeah. Rachel, okay down there? Okay. You good?
Yeah, no.
Some federal agencies or something. So it's kind of hit or miss. Sometimes you fall into it.
You want one too? That can be here. That's relax.
Okay, I'll tell you what, let's, I think we are up to compliment in terms of those okay, all right, she'll be here, those we expect to be coming today. Heather, why don't we start with you and just go right around and all introduce ourselves, because I think some of the people who came late, there's some folks who you haven't met before.
I'm Heather Hallman, I'm the Chief of Staff in the Office of Children, Youth, and Families. Hi, I'm Rachel Berger, I'm one of the CASER members. I apologize, I'm late. They closed the turnpike.
Rachel, we have new people, so if you'd introduce your.
Oh, I'm sorry, I'm the pediatrician at Children's Hospital in Pittsburgh.
Jill McClure, I'm new executive assistant at Office of Children, Youth, and Families.
Jonathan McVan with the Office of Policy and Development for DPW.
Cindy Christian, pediatrician at Children's Hospital of Philadelphia, medical director for the Department of Food Service. Tawana Rumberg, CEO, Pennsylvania Coalition Against Rape.
Gary Einhoffman, Director of Leadville Schools in Delaware County.
I'm Jackie Bernard, I'm an assistant district attorney in Blair County.
I'm Steve Rare, I'm counsel with the Joint State Government Commission.
I'm Yvonne Hirsch, I'm Assistant Counsel at Joint State.
Dave Heckler, I'm District Attorney in Bucks County.
Mary Taylor, I'm counsel at PCCD and counsel at TD. Vicki Wilkin, I'm Senator Ward's counsel.
I'm Kathy Utz, the Director of the Bureau of Policy, Programs, and Operations in the Office of Children, Youth, and Families. Nice to meet you. We talked on the phone.
We have Jim Anderson, Director, Juvenile Court Judges Commission, and staff assistant with the task force.
I'm Carol Patano, Social Service Case Manager, Department of Human Services, Philadelphia.
I'm Gladys Brown, Deputy Chief Counsel for the Senate Democratic Caucus.
Patrick Zerpoli, I'm with the Pennsylvania State Police Bureau of Criminal Investigation.
And child abuse expert from Council. What did that tell you? Very helpful.
Greg Morocco, Lieutenant of State Police.
John O'Neill, the Computer Crime Unit Supervisor for the State Police.
Good morning, Jason Kudalakis, wear many hats, one of which is grasshopper hunter. Cricket hunter.
Which you're not doing very well.
No, I'm failing at that. I'm an
He's the
attorney.
guy with the guns to take care of it.
That's right, I'm an attorney. See
See
that? This is that. Threats do work. I'm an attorney with Avon and Kudalakis. I formed the Children Youth Solicitors Association in 2004 and spearhead Child First Pennsylvania.
Kimberly Early, Department of Public Welfare, Office of Legislative Affairs.
And
John Scarpato, Executive Director of the House Children and Youth Committee.
And I'm CC Kramer, I'm a research manager for the Public Safety Unit under the House Democratic Caucus. I'm here on Representative Germany's office.
very good. Okay, thanks. We were discussing specifically the issues that might relate to legislative needs in terms of the computer and particularly computer crimes relating to child pornography. And I guess you're going to get us the written testimony you're going to be submitting to a committee of the legislature regarding administrative subpoenas. Are there any other subjects that, I mean, our job is to recommend changes in legislation, budget, not so much, frankly. If we were talking about a new creation, you know, what you might want to kick around between now and then, although I wouldn't encourage you to think that it's all that practical, but, you know, talk to your legislative people. If there's some sort of initiative in terms of, like I'm familiar with the RCFL model that the feds are using, maybe some kind of revolving fund that it fund locals participating or something. Just get more money for the state police.
One thing we were kicking around, Chairman, is, you know, and I don't know how far this would go or anything like that too, but, you know, since we kind of lead the task forces, you know, we help, you know, the ICAC matter and everything like that, but, you know, a lot of resources come from us, assisting the local departments. You know, we were kind of looking at, you know, like when our labs do forensic work, there's always a fee that is assessed and it goes to, you know, the restitution end of it. You know, I would love to see something to the effect of when these guys have to rip apart cell phones, analyze them, computers, or something to that effect, and that we would be able to charge some kind of fee like that too, where restitution will come into play because of the man hours and the type of, and the software costs and everything that we have to do that. So I didn't know if this was the appropriate place to bring that up. We have brought it up to you know, some of the legislative liaison, but you know, quite frankly, I you know, I think this is a perfect opportunity to be able to get some of that, because if these people are convicted of these crimes against children or involved in physical or sexual abuse against children, you know, we're assessing lab fees for people that we're doing everything else. But you know, on that end though, it would need to be directly coming back to computer crime units where we can, you know, where it's not just in a general fund somewhere that we never see it. So that is one thing that, you know, would really help us out a lot.
Draft it, why don't, this is an invitation to draft written testimony on any of those subjects that would make you more efficient, so long as now you're not talking about charging my office, but only placing a value on the services which we can assess as in a request for restitution.
Right.
Absolutely. And every once in a while you hit people with some resources. And in fact, authorizing forfeiture, you're generally going to seize the actual implements, but we can now seize the homes of sex offenders, for instance, if it's used sufficiently, if there's a sufficient nexus with the crime. You might think about something like that. But again, I'm not going to presume to speak for the task force, but you get it before us, and maybe without even the need for testimony. I mean, you're welcome to come on the 20th and see where we
I'd
are.
rather do written testimony, because the nice thing about that is too, is if, you know, we can get our legislative liaison to help us draft it, sit down with John, talk about it, and then come up with something that may be meaningful, that's okay with our department too, that we're approaching this area, that can be reviewed. And, I mean, I see no reason why we have to get up and testify if we can provide written testimony being part of staff on this anyway, so.
Great.
Great.
So, is there anything else that we're anticipating? I'd like to make the 20th, whatever hearing we're going to have, and I assume now we're looking at the 20th. Hopefully, the last, yes, I'm sorry, we're at least exploring the 20th and 21st of September are days that, you know, have been set aside by the computer. And I'm hoping, and I guess we're going to look into the availability of funds for lodging, that we can do two back-to-back days. Have that be the that's where we are. Any other subject matter that we're contemplating on the 21st?
You weren't, Jackie and Rachel, you weren't here for it. We're going to have a presentation with regard to Childline, as well as the background check operation, as well as all the IT upgrades that DPW is planning, county connectivity, flow of information, all of that. And we also talked before you got here about a multidisciplinary team testimony. Lancaster County is held in very high regard by our trooper, our sex crimes expert, Trooper Foley. So it will have,
Do you need testimony about that? I mean,
you don't want an MDT,
I don't know, I mean,
like half hour, just in terms of building the record. If you're going to make a recommendation for a statewide protocol, it's nice to have in the record that
thank you.
effective protocols, I would recommend.
I would just, if you're gonna have, don't overlook Dave Natani's or Leach or your solicitor to be at the table for that. You're gonna
Like you
have-
can.
Yeah, good guys.
So that's it. Just now
Yeah,
We can, yeah, let's now, I think our numbers are full and as full as they're, almost as full as they're gonna get today. Why don't we start off with the definition of abuse? I mean, that's-
Did everybody bring the hard copy? We have extra hard copies we did not print out. Heather has hard copies right there.
So, hey, can I, on behalf of me and Rachel, can I hand out this, which came from a colleague of ours, Rachel forwarded it to me, who, you know, it actually, on paper, is very simple and makes some sense, and I think maybe we can use this also to think about how we want to define.
I think it complements what you wanted, actually.
When you get it, take just like a minute, because it only takes a minute to really read it. Like a school teacher. Okay, children, when I say start, you may take your hand. No cheating.
Good morning.
Thank you.
I do.
All right. Yvonne, if you will explain what you do with us.
Wait, excuse me. Just one word of guidance. Our goal this morning and our goal throughout the day is not to engage in a drafting exercise so that we've got specific language. This is to get conceptually, are you comfortable with this type of a model and a definition? So that we can have guidance going forward with regard to fine tuning. So we don't want to waste your valuable time and our valuable time being with you in terms of getting hung up on structure or specific language. So if you can give us, you know, essential elements that you think are lacking or need to be changed, we'd appreciate it if we can keep the conversation focused in that regard. Thanks.
And that was one of the points I was going to make as well, as even though, as David used the term exquisite, it's not quite as exquisite as we like, because there are some internal inconsistencies there. As we were drafting these, we may have used different terminology between different versions. When we sit down and put it into one final practice, then we will take the time to fine tune all those little inconsistencies. So don't get hung up on the fact that we might have said something a little differently between the different drafts. The issue that we might as well start with bodily injury, because physical injury and severe pain, and the fact that we had serious bodily injury, we had serious physical injury, and to try to reconcile those forms, or those terms. The first thing we looked at was bodily injury to represent bodily injury as a simple assault. So we took the first sentence there is the language from the definition of simple assault in the Crimes Code that tells you this is a bodily injury. And then we had discussed them within the group, and we looked at the different ways, because even substantial pain is not a definitive term. So we wanted to look at things that you could sit down, you could go through a laundry list and say, okay, these are factors that tell me whether this was an impairment of a physical condition or substantial pain. And we looked at the nature of the injury, what kind of injury it was. We looked at what the behavior was that caused the injury, like striking someone with a fist. And then we looked at the factors that relate to the child itself. How old is the child? How big is the child? Does the child have a pre-existing condition? Where were they hurt? A punch on the thigh may be a lot different than a punch to the head, and those kind of issues. So I guess the first point is that, will this address that definition of physical abuse?
Just generally, my concern when we come up with, I think bodily injury has been well defined, in part through the simple assault statute and case law that interprets simple assault. And when we create a laundry list as is proposed, there is a great opportunity for interpretation that that's all you mean, even though you say but not limited to. So I have concerns about when we come up with these laundry lists versus terms of art that have been defined with legal consequences that are very familiar in the legal community, both with law enforcement and in child welfare. Rather than coming up with laundry lists, I thought we had talked about coming up with eliminating some of the more ambiguous terms that are complicated through the elimination of the school code, the set-aside, this carve-out of the school code, eliminating some of these things and just using broader terms that can be better dovetail with the crimes code. And this seems to create a laundry list, and my big concern is that the human nature will be is to argue and courts to apply just those things, and we can never have a comprehensive list. It's impossible.
That's a concern every time you create a list of factors, because you always run that risk that, and you put bold, large letters, not limited to, and someone will interpret it to be that narrow list. But our understanding was that for the frontline caseworkers, they're not going to be familiar with those cases and that development of bodily injury, and they need more guidance on how to look at these things.
And I don't disagree with that, but the fix to that is, rather than legislate it that way, is you fix the code to show how caseworkers can rely on these things versus changing the substantive area of the law with a string of terms. I think it's a dangerous proposition to create a list. I mean, you don't see this in the crimes code anywhere, this type of thing.
But you do see it in, like domestic relations, you see it in equitable distribution, you see it in divorce. You always look at what are the factors that come in to determine what's going on. And so that you do give guidance on what you look at it and how you weigh things. But
I generally agree with Jason, but I have to say, this thing that Cindy and I were talking the other day, I generally agree, And in fact, I think the shaken baby syndrome is a perfect example where I would never put that in the code.
Right.
Because I actually had this happen last year where I wrote, this child's been a victim of abusive head trauma. And it didn't indicate. I said, why not? You never said they were shaking. Well, that's not the medical term anymore. So you have to be very careful about using a medical term that can change, because the caseworker had no idea I was talking about shaking, because that wasn't the term we were using. But that said, I think that this thing that Scott Benton is where, Missouri? Louisiana. I cannot think, Cindy and I could not think of one thing that I have ever seen that is not included on this list. And it has enough ors that it gives enough guidance. I mean, I agree that the lists are hard.
This would be a great tool to hand out through DPW for policy clarification to a bulletin.
Or this is
incorporate
a
the code.
digital dashboard model for a caseworker who's
Right.
responding and
Right.
needs
Sure.
Right.
guidance, right? This,
Sure.
But it has to have the statutory underpinning.
Right,
I mean, that is the terribly difficult challenge that these guys have, that we can't write this in the statute. We can write
We could write this.
the
but not-
underpinning
right,
of
right.
this. This is the chart that you give somebody to apply, but it has to be,
Can't you say, this is, child abuse is defined as this, and then, say like see appendix A, and this is something
No.
like see appendix A?
no,
For you
no,
to do,
no, I don't, I would, I'm sorry.
In terms of, we always do in statute, if we want the department to clarify something, we require that they do it in
Right.
regulation. I think that's what you were talking about.
Let me say, I don't want us to get off on another topic, but I think, I guess we don't have any professional educators here, so we can all gang up on them. I have the belief that they would rather not have child abuse people, and certainly not law enforcement, ever messing around. If we got a teacher that's doing something, let's put that under the rug, or let's get, I read something in an article about the situation that's going on in Allegheny County now, where some apparently knowledgeable bureaucrat in there, and I'm getting the impression it's either their child protection or their education bureaucracy out there that says, oh, well, we think there's some regulations that give us the right to investigate. I would urge, I don't want welfare writing any regulations they don't have to write. I certainly would never recommend to the legislature, oh, well, they'll take care of it.
well, the practical problem is, excuse me, David, it takes 2 years to get regs passed.
True, but we could always do legislation, requiring the legislation that they do guidelines that take place until regulations.
You're delegating, I mean, we're just an advisory body to the legislature. The legislature needs to have to say, if you're going to define child abuse, the legislature has to be who does it.
So, could you do me a favor? Could you read me the definition of child abuse that you have drafted here? Because I'm used to reading like definition, and then there's definition, not, okay, let's define every term that we're gonna use, and then we're gonna make, I want to hear, like, how simply can we define child abuse? Like, can Heather like type up on the screen for us a 1 or 2 sentence definition of child abuse that we can then go back and pick apart all the different words in that definition? But you're in,
First on page 5.
Starts on page 5.
Body, page 5.
Yeah, at the bottom of page 5.
The body of it is page 6.
Yeah.
The child abuse shall be any of the
Page
following.
6.
Go to the bottom. Heather, go to the bottom.
It had actually occurred to me that as we're doing this, and I didn't think of it soon enough, was that we should bring a clean version then. Because we have 2 competing interests going on. You want to be able to present what you're changing. So you want to be able to show what the new language is and what the old language is. But you also want to be able to present it in a readable form that makes sense. So moving forward, I hadn't even told the student yet, but I kind of made the decision that to have 2 versions. The one where you can see the changes, and then the one where you can just read it and see how it sounds.
Right.
But,
So can we hear, like, can we think
Right,
about
all right, right now-
what a clean version would look like?
yeah, the one thing bodily injury to a child through unjustified force. 2, any reckless or intentional act or failure to act that causes or substantially contributes to serious mental injury to a child. 3, any recent act, failure to act, or series of such acts or failures to act which creates an imminent risk of bodily injury to or sexual abuse or exploitation of a child. 4, any reckless or intentional act or failure to act that causes or substantially contributes to the sexual abuse or sexual exploitation of a child. And then 5, serious physical neglect by a perpetrator constituting prolonged or repeated lack of supervision or the failure to provide essentials of life, including adequate medical care, which endangers a child's life or development or impairs the child's functioning. Now, with that, we made a couple of decisions that recent only applies to bodily injury and imminent risk of bodily injury and sexual abuse and exploitation, kind of by definition. Serious mental injury and sexual abuse and exploitation in and of themselves do not have a recent requirement because of the time frame over which those kind of situations will evolve, that to limit it to recent may prevent you from getting some of those cases where the child may have been sexually molested when they were 5 years old, but not reported to anyone until they're a teenager. The other thing we did was leave, because we still haven't made definite decisions on how we're going to define perpetrator, we left perpetrator in serious physical neglect because a caretaker or a perpetrator is the only person who really is capable of committing serious physical neglect. But we took perpetrator out of all the rest of them with the expectation that we would be making a distinction between a caretaker and a non-caretaker in those types of abuse. The other thing that we did with that is we have some concerns, and we've had the question raised about reckless or intentional, and should we also include knowingly to get to intent. And we've also had concerns about what does substantially contribute means, and we may have to revisit that. The other thing we added was the paragraph, and having discussed this, I think we need to include a comment to explain this better, is paragraph 1.1, which says, an intentional act or failure to act under the first definition of child abuse shall be based on the intent of the individual to engage in such conduct and not whether the individual intended to cause the resultant injury to or sexual abuse or sexual exploitation of the child. And that's aimed at the belt buckle case where the person swings the belt buckle, wants to hit the kid with the belt buckle, but didn't mean to take his eye off. So that's what that language was geared at. We pretty much decided we need to write a comment to help clarify that. We struggled for a long time with the language on that one, trying to decide how you deal with that intentionality of this, to commit the specific act with the intent to harm the child, but not to produce the harm you did. So we're going to be writing a comment on that one. But, so you look at it, and you've got acts or failures to act that, for lack of a better word, deliberately are intended to harm, create bodily injury, that are recent acts or failures to act that create imminent risk of bodily injury or sexual abuse and exploitation. And then we have behavior that causes emotional injury and behavior that causes sexual abuse. And then you go back and you look at, what we haven't done yet is go through, we're looking at emotional injury because there's some clarification issues that have come up with that about what, how you define emotional injury and trying to bring some more clarity to that. Just having spent some time looking at how other states define it, once again, we have a very narrow, very strict interpretation of emotional, mental injury that is in a minority among other states. With sexual abuse, we really haven't done much with it other than try to clean it up. And then the imminent risk, we still have to play with that language and what imminent means. But, so you've got 4 categories of abuse. And the one that's had the most focus, the one we've obviously spent the most amount of time on, is the bodily injury. And with the idea that you're going after, you're getting away from severe pain, you're getting away from, and you're trying to broaden it to include more injuries, and then trying to give people who have to interpret it some guidance on how to determine what those injuries are. I'm not sure, and maybe what we need to do is, like what we say, look at the nature of the injury and not have the laundry list, but still have the person considering what kind of injury is it? Is it a broken bone, or is it a bruise, or what is it? And I mean, if people are concerned about the specificity, we can narrow it that way by not providing the examples in the list, but still provide those factors. What's the type of injury? How was the injury caused? And again, how big is the child? How old is the child? Are there other conditions? And maybe narrow that down a little bit.
If I could, one of the things, and again, trying to impose this criminal model on this definition, one of the important concepts is the so-called mens rea, the state of, is it intentional, is it, if knowing is hard to distinguish, or at least reckless. It occurs to me that some of the factors that are detailed here really might be more appropriately applied to in order to determine the mental state of the actor, you consider these things. Because we know, and I think with regard to physical injury, that's the tough part that you guys and then law enforcement and everybody have to deal with. Kids get hurt. And you're trying to figure out what physically hurt them, and then what was the state of mind of the person who was physically responsible. So, on the one hand, I assume you guys, and I'm addressing the doctors in particular, are more comfortable having the laundry list just like the law, and I mean, we can adapt, whatever to this laundry list, but having that, all right, you got one of these, and it causes some, it amounts to at least impairment of physical condition or substantial pain, which you would think it would. Now, we're in the ballpark, but we've still got to look at how it was inflicted, because it could be accidental, and I mean, that's the problem. One of the big weasel words is non-accidental.
Well, no,
right?
but here, causes a minor, okay. Yeah, but, I mean, this, if you look at this physical abuse defined, okay, we have reckless or intentional,
Right.
right? They have purposeful, knowingly, or recklessly, right? I honestly, I get the idea of reckless, and I don't know if intentional is the same as purposefully and knowingly.
Pretty much.
Pretty much? Okay. Is there reason to use one phrase over the other phrase? Or?
Well, intentionally is used in the crimes code, and it's been, as Jason says,
So it's reckless.
it's been used, as is reckless. Purposefully, unless,
So we
I
like
mean, it's just,
intentionally. Okay, that's fine.
Potentially or recklessly, would be the parallel.
yeah, and knowingly is sort of the equivalent of, if you look at it, it's separately defined in the crimes code, but it's essentially, you're practically certain, in the real world, it's hard to distinguish between that and intentionally, I intend to produce a result. Knowingly, I am aware that it is practically certain the result is going to come from my conduct, is I think roughly what the crimes code says, and how you
If
distinguish
we
those.
take this here. And then, like, what I like about this is that you have all these different, you have like, almost everything you listed plus more, because you have harm to vital structures, you have functional impairment, you have specific acts that may not even result in a physical injury. You have, and we can talk about pain and suffering, and then they have the exceptions in there. So I don't know, I just think it kind of nicely, it's a very broad, but it addresses all these different kind of issues.
Well, the other issue to address Jason's concern is that we could empower the department to add to this list regulatorily, so that we enumerate these in statute, and then empower the department, you know, if new medical syndromes or whatever come up, you have the ability.
Disease reporting.
Yeah.
I mean, if people think that's a bad idea, I mean, I've heard some people think it's a bad idea, but this is not, these are like, I don't know, it just, what I like about it is it breaks it into different categories almost, which we struggle with. And somebody's very nicely broken it down into different categories.
I don't think you can draft legislation this way, but.
Right. Well, to me, what would help me with this one is in terms of looking at it, if I understood, this definition is offered for the purpose of accomplishing what? What specifically are we attempting to do by redefining child abuse in this way? Because I look at what comes to mind is by not having a reference to perpetrator, I think school fights, school assaults are child abuse under this statute, are they not?
Under what?
Well, on
this one?
the new definition. If you don't have any reference to perpetrator for the physical altercation, so it isn't caretaker, it isn't. Do you not bring into the, thousands of, cases that happen, pick week, month, depending on it, involving just juveniles alone, or non-care type or kind of assaults, which I think there seemed to be a consensus that we wanted to capture child abuse. We wanted to know if children were being abused, even if they weren't under the current definition of caretaker or perpetrator under our current definition. But I think to me, I have to think through what is the expectation by expanding this, because to me, it doesn't make any sense at all that some reporter, particularly an expanded mandated reporter, would have to be worried about making that referral to Childline, and the Childline, that doesn't make any sense to me. So,
But can't we just carve out an exception? We all agree, presumably as a matter of policy, that child abuse isn't something that's perpetrated by another child on the victim of child abuse.
I think it's for child welfare definition, right, that we still, this is really a child welfare definition.
child welfare definition.
Right, that it is appropriate to have like a caregiver or a caretaker as part of that definition, as long as in those circumstances where we know the child was abused, but we investigators cannot identify the specific perpetrator, we still define that as child abuse. But I agree,
Right.
you don't want every crime against a child coming into Childline, because they're not all by their caregivers. If a kid gets sexually assaulted on the playground by a stranger, that's sexual abuse, but it's not by a caregiver.
But don't we want that going into
We do.
Childline?
It does.
Okay.
Well,
But are these three different, one issue is who you have to have a caretaker. One issue is you have to have an action, and one issue is in what way, reckless endanger, whatever. But I think this list has nothing to do with the caretaker issue. It has to do with how we define the actions.
That's
And
correct.
so the question
Two
is, we want a
separate
list of actions, and I think what's here is a bad middle ground, because it doesn't say enough things. It says them in an unusual way. Like, I could even say broken bones, okay. Probably the word should be fracture, and it probably shouldn't have an S on the end, because then if you only have one, and then this word, the shaken baby, it really should be abusive head trauma. But then,
That's
so I
exactly
think if
the
you're gonna do,
concern I
right,
have.
so if you're gonna do a list, it's gotta be a really good list, or don't do a list. But I think what you're raising an issue of caretaker, it's not that every one of these things is abused, because it also has to be, you have to have an and.
Well, you don't don't have to have an and on the definition of child abuse, which we're looking at here. It is simply, it is one of these, and one of the criteria is any recent act or failure to act that, or attempts to cause or substantially contributes to bodily injury. So that would be one definition, so that, you know,
But
so
then
I,
that comes into play in the rest of the statute in how you treat that. And if you say that kind of abuse by a caretaker is a child protective services issue, then those would go to child protectors. But and then you say it's still child abuse, but it's not a caretaker, it should go to general protective services, but it's still
no,
considered
I'm talking
child
about a
abuse.
fight with the police need to be called.
Well, the thing with the school fights, and I finally remembered where I saw it, is in the crimes code, you have an exception to one of the assault provisions that says, basically, a schoolyard scuffle is not an assault. And maybe we need to borrow that language and clarify that in here in some way. But that there is
Where does it say
language.
that a schoolyard fight's not an assault?
Um,
It may not be an M2, it may be an M3 mutual scuffle, but
Yeah,
still a
it's-
crime.
it's grading, I'm sorry, it's in the
Right,
grading.
right.
Yeah.
Grading,
But-
Yeah, but it's a grade, it's just, I want to make sure we're clear, as we are on the record here, right? It's still a crime to get in a schoolyard
Yes,
fight.
but
I don't want
it's
this task
treated
force to
differently.
be
It's
on the
not-
record saying something to the contrary.
But Philadelphia schoolyard fights are aggravated assaults. So you've got ag assault happening. Middle school ag assault, or the police are responding to.
But this
We-
Let me see Ellen.
To go back, the CPS law, I think, Child Protective Services law, like, it does address, in my mind, it has always addressed caregivers, family situations. Because, yes, a child is sexually abused, if they're sexually abused by a perpetrator on a playground that has nothing to, but when those calls come in, they go to the police, like, child welfare doesn't have to worry, I would think, does child welfare have to worry about the safety of that child in their home environment because of what happened to the child? And if the answer is yes, then it's a child welfare issue. And if the answer is no, it may still be child sexual abuse, but it's a police issue.
Correct.
Right, so this law, what we're drafting, is supposed to be addressing the in-the-home safety, well-being of the child, right? Because we still have a crimes code that identifies sexual assault of a child on a playground.
But as Jim articulated,
So I'm arguing for a caretaker
Well, that's, I'm
as part of the
just trying to
definition.
clarify that
Get
the
it
only
here.
place
This doesn't get it.
perpetrator is kept is really in the neglect.
well, it's
Because this is a dramatic expansion of,
We don't want, we don't
well, I'm just,
necessarily-
I'm trying to get people to understand the deal.
And this is, I created this whole bugaboo to begin with, I wanted to get that out of there, and I know it's the biggest burr because of the juvenile. But, but at any rate, the only, and I'm thinking we can deal with this with words, the two reasons why I wanted to take perpetrator out is, number one, we do have to change the proposition that it's not child abuse if you can't prove who did it, if it's mom or pop in particular.
Correct.
So that right away, either we could leave perpetrator in and then carve out exception,
Right.
or we get rid of perpetrator and say something else. But, so that's sort of a separate policy issue we have to thrash out. The other concern that I would have, you're setting up a straw man in the sense that, okay, there's either a rape on the playground, what I always call, guy jumps out of the bushes, doesn't know the person at all, or it's a rape in the home. The concern that I think has children and youth implications in a lot of cases where either physical or sexual abuse happens to kids is even if the parent or the paramour didn't do it, were they negligent? Did they create a situation in some way? In other words, if
Not protect the child.
yeah.
Sexual Abuse Act is not what the crime
Correct.
is, it's the
We've got,
neglect.
so you're
Right,
saying
got it.
that's
Failure to
still
act.
covered
Yeah.
up. Okay,
That is covered.
okay.
All right, so we want, I think, do we want to put like a caregiver back into our definition?
I yield.
The CPS?
Well,
I'm
I-
sure
I-
consensus on it.
Jason?
Can I just have a few minutes on the floor to talk? I don't know, and I apologize, the solicitors submitted some suggestions. I'd like to go to that for a minute, because, no disrespect to the drafting we got, it seems that we've gotten a little bit, at least away from what I thought the direction was we were going. I mean, we're still using imminent risk, and I thought we said we're done with that. If we could just go walk through some of this, the definitions that were suggested were for child abuse, and I apologize, the pages weren't numbered, really tried to dumb it down and make it very, very basic language, and break it into several categories and make it very simple. And we eliminated the imminent risk section and make it an attempt section. We try to make it terms of art that are consistent with what practitioners, judges, and law enforcement know, and make it consistent so that it talks with the criminal code. We eliminated all types of injury to consolidate into one definition of bodily injury that's subsequently defined as impairment of physical condition, substantial pain, which is defined in the law, substantial risk of death, serious or permanent disfigurement, or protracted loss or impairment of bodily function of any bodily member or organ. That's defined in the Crimes Code. So it all talks with the Crimes Code. If you then look at the definitions of child abuse that are suggested, for example, physical abuse, they're broken down into 3 major categories with some suggestions that are probably debatable. But the first one is an attempt. We all in the law know what that means. It's an intentional act. It's a specific mens rea to cause the bodily injury. There's an act of commission, so there's some duty. There's an intentional reckless component to that.
By the way, does everybody have this? I just got it last night, so do we all know what we're dealing with?
And acts of omission, which is a failure where you have a duty to act. It's really clean and cut, I think, the way this has been suggested. And it's consistent through all the definitions of emotional abuse, sexual abuse, and then we add an additional section of physical neglect, which really talks about the necessities that are required to be reported, and that's the caregiver that has the duty to do so. And then if you go back to the definition that's following bodily injury, and there is a definition of perpetrator. And we have, it is a laundry list, but it is those that are significant roles. Parent, paramour, former spouse, any person that's within the home for some purpose, because you always have the grandparent that's babysitting or staying over for the weekend. They like to say they're not in a caregiving role, but they're there, and they fall through the cracks not being identified as a person. You need to catch that person. So we use has access within the kid's home. We're not talking about the burglar. We're talking about the invited person that's there on some specific purpose and commits one of the enumerated crimes against the kid. Persons that are related within the child's consanguinity or affinity. And then the catch-alls are responsible for the child's welfare. Paragraph 7 is the employment relationship, camp counselor, coach. And I'm not sure why paragraph 8's on there. I don't think it's any different than 6. So I think if you haven't had a chance to look at this, I do, on behalf of that association, apologize for its delay in delivery. But I think it's really basic. And maybe that's a jumping off point to try to look at this. So I apologize for taking time.
Jason, what is under perpetrator B? I'm not sure I understand what that is intended to do.
A current or former paramour of the parent?
Any
Perpetrator
Oh, B? I'm sorry. Well, I thought we said we were trying to include children who have been abused. All children have been abused. And right now, you have to have a special relationship under the definition. And this was trying to avoid the situation where you have a young child that's the perpetrator. So you could have a kid in the home or a kid at a camp counselor, babysitter, or something like that. And we just thought that the age of 13, age of 14 is really where you can be responsible for negligent conduct. And there's some statutory breaks in the crimes code around the age of 13 as well, age of 14.
That's any person, so it's either A or it's B, and doesn't B mean any person who's over the age of 13 who is a child?
Yeah, that needs some,
It's almost like you want to, really what you're trying to say is if you're young, you're not a perpetrator of child abuse, as opposed to, so
Right.
it needs to be flipped around.
Right.
Can I also make it just a general recommendation and see what consensus goes, that we shift to caretaker as our term of art and get away from perpetrator, because
Yeah.
anybody who harms a child is a perpetrator. But for the purposes of children and youth response, we're talking about caretakers because the response, the systemic response, is to the family to try to provide services to correct the situation.
I think that's.
When you have that very awkward language about, you're a mandatory reporter and you have to report abuse against a child, even if the abuse is committed by a non-perpetrator. It makes your head swim.
Wait a minute, I thought what we were trying to do is get as many kids that have been victimized into the system. If you limit it to caretaker, that's a very, very narrow definition.
Well, and that's the thing, one way or another, and now if I'm knuckling under on this, you and I together have got to be sure that, well, my problem is, I'm sure we can do it either way. We've got to be sure if we're going to say on perpetrator, now caretaker, then we have to say, for purposes of, and maybe we need a separate policy determination about this, I think Childline should hear about it every time any child is abused. The victim of a crime, hurt by somebody else intentionally, within whatever definition we come up for abuse. Whether it's whether it's a terrorist, a guy on the street, no relationship, whatever. I'm recognizing that
Right.
that by insisting on getting rid of perpetrator, and I think Mary's suggestion is excellent, we call it something else, that I've complicated things, and Rachel, that's what you're chewing on, okay, or I'm sorry, Cindy, you guys
It's
are,
great.
you're fungible.
I guess I'm confused here. We're not making law about who can call Childline. We're just making laws how you define abuse.
Right.
All these kids should get called into Childline, but you're not going to define them as abuse.
No,
But we're not changing who can call, right, and that you can't respond.
Well, okay, but perpetrator certainly got mixed into that.
But if we're unlinking the need for a perpetrator from the action of abuse,
Now,
then
if you're a mandatory reporter, we are changing things dramatically. If we say that child abuse, any abuse against a child needs to be called in, because as a mandatory reporter, you have to call Childline when right now it's a perpetrator
Under 16.
of any harm.
Yeah.
Okay, the non-perpetrator language is in there too.
Right, yeah,
Visualize this
that's
for
great.
everybody.
It's 2006.
Okay,
Right,
we have child abuse. Anytime you're concerned that a child is being abused, let's get that child into the system. Then the next triage point is, does this meet the definitions under the CPS law or the General Protective Services law? Meaning that it's child abuse committed or by a caregiver of a child who we have to worry about the child's well-being in their home situation. Or, and it could be and/or, is it child abuse under the crimes code where a child has been physically assaulted, sexually abused, severely neglected, et cetera, et cetera? I'm sorry. Okay, and that decision is not going to be made by the public, but that has to be defined in our child protective but we have to triage it this way. And sometimes it's both, that yes, it's a crime, and yes, it's under the CPS law, and sometimes it's one or the other. But we're supposed to be dealing with the CPS law, right?
But sometimes it's not a crime. It may not rise to the level of a crime,
Right.
but it may be something that happened by somebody other than this caretaker that's harmed a kid. Don't we want to count those kids?
Yeah, we would.
Everybody
Okay.
agrees to that.
Yeah.
it's not under CPS law.
Why?
Well,
It's not going to be the crimes code.
Hold, one person at a time.
My only concern about funneling all those calls to Childline is, and I brought this up previously, is what,
don't know that I have the confidence right now to say that we should be making that decision, that all the calls go to Childline, because we need to know that Childline is capable of handling those calls. And what are we expecting Childline to do with that information? Are we expecting them to be the first place the decision is made, that they're gonna refer to Children and Youth Services locally, and then they're gonna figure out which police department? I mean, there's a whole bunch of issues just involved in that one
No, I have a
decision.
question, just really stupid. What you just said would only be applicable to mandated reporters, correct? And mandated reporters,
Well-
right now, if you've got a child and you see the injury, you have to call Childline now, right? Right?
Yes.
So,
correct.
is there,
Well,
is
it's called
Rachel,
Childline, called the county.
pardon me?
The county who calls Childline.
You have to call Childline. So Rachel,
call one or the other.
Right.
in prior meetings, you said that the district attorney of Allegheny County is telling your institution that you have a dual responsibility to also call the DA's office or the police